The Supreme Court has reprimanded Centre for not releasing stress fund money in Amrapali Builder case. During the hearing, Centre told that there is a supervisory issue between SBI CAP and NBCC. The apex court said that we are concerned, and if matters are not sorted out, will invoke Article 142. The Supreme Court has pulled up the central government for not releasing money from the real estate stress fund created by them towards completion of the Amrapali projects, despite being asked to do so repeatedly over the last 3 months. The bench, comprising of Justices Arun Mishra and UU Lalit, asked Solicitor General Tushar Mehta why money from the rupees 20,000 crore fund was not being moved by the government. This came after senior advocate Harish Salve, representing SBI Capital, informed court that there were certain issues that were creating an obstacle in finalizing SBI Cap's final proposal to finance the project. Salve mentioned that one of the problems was supervisory issues between the SBI Cap and the NBCC, and that the latter was reluctant to become a party to a fixed-term contract. On this, Justice Mishra said that we are concerned about what is happening between SBI and NBCC. We will use our power under Section 142 if needed unless you work out a solution to this problem. Having noted Salve's submission, however, the court granted SBI CAP time to sort out the issues. The court has also clarified that dispersal of the payment by SBI should not be target-oriented with respect to NBCC. Supreme Court also asked the SBI CAP to consider the rates of interest at MCLR rates, having opined that the current rates was not justified. Thus, on the aspects of bank financing, the court orders as follows. They have prayed for time as there was only certain aspects which remain to be creased out, and they are likely to be sorted out, including the issue of rate of interest, supervisory issue between the NBCC and SBI CAP, and stage of the funding, whether it is to be target-oriented by the next date of hearing. Dispersal to be made by the SBI CAP should not be target-oriented. Let all this aspect be worked out by the next date of hearing. Allowing the prayers to find out the feasibility of formations of consortium of banks which can extend finance to the various projects based on the unsold inventories and securities. The court ordered that the committee as well as the receiver are permitted to work out details and place the same before this court. Justice Mishra allowed the committee to evaluate the projects correctly and then auction the same through MSTC. With regard to the IMT Manesar property, the court permitted the following 3 proposals made by the receiver: to demand a payment of dues as ascertained by auditors from the allottees who are in possession of units, registration of allottees, sale of those units which are not occupied through MSTC. The court was informed by the Corporation Bank and the UCO Bank that a new MOU had been sent to the court receiver. The court directed the receiver to consider the MOU and report back while allowing home buyers to avail of loans as proposed by the banks. Let the receiver look into the MOU and reports back to this court on the next date of hearing. In the meantime, home buyers who want to avail the loan facility as proposed by the UCO Bank and Corporation Bank are free to do so. Let the concerned branches disperse the loan to them as per the MOU. The court also allowed the central government request to be given access to the forensic auditor's report in relation to all Amrapali companies, its subsidiaries and shell companies in order to scrutinize and investigate the extent of the tax evasion. The matter will again be taken up for considerations on August 19, 2020. Bureau Report.